Awesome. Uh, Good afternoon. This is the third meeting of the task force for to study transparency standards for states attorneys. I am Senator Charles Sidnor, Senate Chair on this committee, uh, and you'll hear also from Delegate Moon, who is the House Chair. This afternoon, we have our presentations are segmented in uh, three different segments. We'll be listening to a presentation on data collected by the Maryland State's Commission on Criminal Sentencing Policy, which will be given by Dr. Soleil, who's the Executive Director of the Maryland State Commission on Criminal Sentencing Policy. Thereafter, we'll have a presentation on data collection by the Administrative Office of Courts. They're here with the team, and will be presented with a presentation on case management systems that are in use in Maryland from our state's attorney from Frederick County, State's Attorney Smith, uh, Ryan Wexler, who's the Deputy State's Attorney out of Montgomery County, and Darren O'Brien, who is the Assistant State's Attorney and Director of Management Information Systems for Baltimore City's State's Attorney's Office. Uh, so with that, I'll turn it over to our other co-chair.
Not much to add from the good senator's comments. Just a quick reminder that this process is intended to go rather quickly. And so hopefully we're all gathering thoughts and beginning to form nascent conclusions as we head towards December recommendations, if any. So just with that, let's begin.
All right. With that, we are going to kick off this afternoon with Dr. Soleil.
Okay, great. Thank you, Senator Sidnor and Delegate Moon. I'm going to share my screen here quickly. And hopefully you'll all be able to see it. All right. Sorry, I had to. Okay. So I appreciate having the opportunity, and my goal today is to just share some information with you about the information that is collected by the Maryland State Commission on Criminal Sentencing Policy, which we refer to as the MSCCSP, or Sentencing Commission for short. We certainly recognize the importance of these discussions, and my hope is that this presentation provides relevant information as this task force prepares for its recommendations. So I'm going to describe the Sentencing Commission's data, which it collects via the Sentencing Guidelines worksheet. I will review various sections of this worksheet to highlight the data points that is collected. I will be brief as some of this information has already been covered by Mr. Gibson during the first meeting of this task force. The guidelines data are already publicly available and widely reported, and we are happy if these data and the Sentencing Commission's practices and policies regarding sentencing data collection and transparency can provide useful insight to assist with this task force goal of establishing transparency standards for states' attorneys. However, as I will describe in this presentation, the Circuit Court sentencing data that the Sentencing Commission collects cannot describe prosecutor office policies or any prosecutorial discretionary decisions, and therefore they wouldn't be sufficient for the purposes of this task force. So as I discussed, I will briefly review the data points that are collected via the guidelines worksheet. This worksheet is completed using an online application, which we call the Maryland Automated Guidelines System, or MAGS. The primary objective of the sentencing guidelines data is to collect offender and offense information, which are used to calculate the sentencing guidelines. And then we also collect the corresponding sentencing information for those offenses. So I thought it'd be helpful to start by talking about what are the scope of the sentencing guidelines data. What I've listed out here is sentencing events that are on the left side of the left column require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So those primarily include circuit court original sentencings and jury trial prayers and appeals from the district court, but only if a PSI is ordered in those instances. In addition to original sentencings, we also are required to collect guidelines worksheet for reconsiderations or modifications and 3-judge panel reviews that involve a crime of violence, but only if there is actually an adjustment made to the original sentence. The sentencing events that are listed on the right-hand side here are excluded from guidelines coverage. So those would be any prayers from jury trial from the district court or appeals from the district court, unless, again, a PSI was ordered in those instances, which is very, very rare. PSIs are only ordered in those instances in less than 1% of prayers or appeals. Also excluded are offenses that don't carry possibility of incarceration, local violations, sentencing hearings in response to violation of probation, criminal non-support and criminal contempt cases, and finally cases that are adjudicated in a juvenile court. Consistent with how sentencing guidelines are applied in most jurisdictions nationwide, the guidelines were designed to be applied to the more serious criminal cases, and therefore their scope is limited to circuit court original sentences. And as I mentioned earlier, they do not apply to the less serious cases that originate in the district court and move up to the circuit court via an appeal or a jury trial prayer, unless a PSI is ordered, which again is very rare. So just to give a better picture of like what is the sentencing guidelines data capturing, it's important to remember that the guidelines data are limited to convictions. So charges that are dismissed, nol pros, deaded, or merged at sentencing are not used to calculate the guidelines. Therefore, they are not collected as part of the sentencing guidelines data. And this graph or image that's showed here is just to illustrate the scope. The Sentencing Commission received just over 11,000 guidelines eligible sentencing events in fiscal year 2019. And I chose 2019 primarily because it was the last full year before the COVID-19 pandemic. So to me, that's kind of a more complete picture, because we know in the subsequent years, the volume of cases dropped substantially, although it has been coming back up to the numbers pre-pandemic. As a comparison, during fiscal year 2019, there were over 780,000 prosecutions in that fiscal year based on the number of circuit court criminal filings, district court criminal filings, and motor vehicle findings. So I'm just sharing this point to illustrate that the guidelines eligible sentencings represent a smaller subset of the state's prosecutions. So the guidelines worksheet is generally divided into 7 sections. We have offender and case information, convicted offense information, offender and offense score, the victim role at sentencing, the individual and overall guidelines range, and the sentence and departure information. The state's attorney's office is responsible for providing much of the information that is provided on the sentencing guidelines worksheet, including almost all of the information listed on the first 5 bullets points listed here. When a PSI is ordered, the sentencing guidelines worksheets are calculated by a P&P agent as opposed to the state's attorney's office. In the most recent fiscal year, PSIs were ordered in approximately 10% of guidelines eligible sentencing. So 90% of the guidelines cases, the state's attorney's office is providing much of the bulk of the information on the guidelines worksheet. All right, so here is an illustration. I know there's a lot to look at. Don't really worry about trying to figure out all the fine fault small print here, but this is a guidelines worksheet that I'm illustrating, and the section at the top that I've highlighted in yellow collects demographic information. And so I'll just pop out here to show you what that information includes, and that's things like the offender's name, SID, which is the state identification number, gender, date of birth, jurisdiction, whether a PSI was ordered, the disposition type, and type of representation, whether it was private, public, court-appointed, or self-representation. As we've noted here, it also includes ethnicity and race of the offender. And the categories that we measure on the guidelines worksheet are consistent with those that are required pursuant to state government article 10-603. And so we use the same guidelines, which I think mirror, if I'm correct, what is required in the by the U.S. Census. Finally, this section also includes whether the sentencing event involved a Maryland Rule 4-305 reconsideration or modification, a Health General 8507 order, or a 3-judge panel review. The next section pertains to the convicted offenses in the sentencing event. And again, I'll pop it out here so it's a little easier to see what we're talking about here, where the information included here is the offense date, the convicted offense title, the seriousness category, which is the commission's ranking or classification of offenses, the CJIS code, the Maryland statute, the statutory maximum penalty, the mandatory minimum penalty if that's applicable, and the case number. The next section is the offense score. For drug and property offenses, the offense score ranking is based solely on the seriousness of the offense. That's what I was referring to earlier as the seriousness category. But for person offense, the offense score is calculated considering 3 additional factors. And the additional factors include whether there was victim injury, whether there was weapon presence, and whether there was special victim vulnerability. And then the next section is the offender score. And again, popping that out so you can see it a little bit better. The offender score is basically a summary scale, which ranges from 0 to 9, which measures an offender's criminal history. And that takes into account 4 factors. That's the relationship to the criminal justice system at the time of the offense, whether there's any juvenile delinquency record, prior adult record, and prior adult probation or parole violations. The next section of the worksheet is at the bottom left, and this collects information about the role of the victim at sentencing. So the information that is collected here is things like, was there a victim? Was the victim able to participate in sentencing process? Was the crime victim notification and demand form filed? Was the victim notified of the terms and conditions of a plea? Was the victim notified of the court date for sentencing? Was the victim present in sentencing? Was a written victim impact statement prepared? Did the victim or the state make a request for an oral victim impact statement? Did the victim or state make a request that the defendant have no contact with the victim? And then did the sentencing judge order the defendant to have no contact with the victim? As you can see here, these questions pertain specifically to the role of the victim at sentencing. Information about the demographics of the victim are not collected. The next section is the guidelines range, and this includes the individual guidelines range as well as the overall guidelines range for this whole event. So if you have multiple convictions in a sentencing, you will have a guidelines range for each conviction as well as an overall guidelines range for the sentencing event in the total. This section also includes the departure reason or reasons if the sentencing event resulted in a departure from the sentencing guidelines. Final section that I will highlight includes the sentence information. So this is all the information that's collected here, including the total sentence imposed, whether there was the amount of suspended time, credited time, if any home detention was utilized, the amount of jail prison time, that's time going forward after sentencing, as opposed to any credited time before sentencing, probation length, community service hours, if there were any ordered, criminal fine, if there was any, whether there was utilization of any corrections options program or other alternatives to incarceration, whether the judge made the announcement in court that a minimum of 50% of the sentence has to be served. That's for crimes of violence only. So people that are convicted of crimes of violence, there is a statutory requirement to announce the minimum time that individuals serving after sentencing. Whether the judge made a written request for notification of parole release hearing, and then finally, whether the victim court costs were imposed. Okay, so that's kind of a lot of information about the data that we do collect, but relevant to this task force, I also want to just talk about, the sentencing guidelines data provides really useful, detailed information that's relevant to sentencing. But with the specific to the work of this task force, it's also important to note some of the cases that where the data is not collected for. And as I mentioned earlier, just kind of recapping, the guidelines are limited to guidelines eligible cases. So that's original cases sentenced in the circuit court, as well as reconsiderations, modifications, and 3-judge panel reviews involving a crime of violence. Also, as I previously noted, the guidelines worksheets are not required for district court cases, jury trial prayers, or appeals unless a PSI is ordered, or probation revocations. The guidelines data therefore do not include a complete enumeration of all criminal sentencings in the state. Additionally, as I know, the guidelines data are limited to convictions and sentencings, and therefore they represent a small portion of statewide prosecutions. And then finally, as I've kind of noted here, some of the variables that were mentioned in previous presentations of interest, they can't speak to other factors such as bail decisions and the characteristics of the victim, such as gender, race, zip code, and relationship to the offender. And further related to this task force, the guidelines data does not collect information about charges that don't result in conviction, right? So if there's a difference between the initial charge and the final charge, and any charges that were dismissed, or the reason for why charges were reduced or dismissed, and whether the offender was offered any type of diversion or other alternative sanction. So in summary, the guidelines data provide, I think, really strong, important information related to sentencing in general, and certainly provide some insight about the work of prosecutors, specifically information about the offender's criminal history and information related to the final conviction of offense and the demographics of the defendant. And obviously, they also provide, for those guidelines eligible cases, important sentence information such as incarceration rates and length of sentence. But the guidelines data do represent a subset of criminal sentences in Maryland. So given those kind of summaries, I just thought, I wasn't necessarily asked to do so, but I thought I would just finish off with some suggestions. You know, this task force is charged with studying the possibility of establishing minimum transparency standards for prosecutors. And to achieve that goal, my suggestion would be the task force to focus on identifying a core list of measures. And I believe we may be able to reach some consensus about that and what should be collected, as well as agreeing on what information should not be publicized, such as, you know, I know that was mentioned in Mr. Gibson's meeting one, you know, grand jury proceedings and victim contact information. I think we could probably have a lot of agreement about those. But I think the reporting of a list of core measures can be accomplished without requiring every prosecutor's office in the state to create a new case management system or to hire a data analyst, or, you know, which is something we've discussed in the past. I think instead we should review private funding opportunities to work with the prosecutor's existing case management systems and identify a process to extract already existing common metrics from their respective systems. I don't think we have to find ways to reinvent the wheel. Most prosecutor case management systems are already collecting many important common metrics, such as the information about the charges that were dismissed and the initial charge versus the final charge, whether pretrial diversion or other alternatives to incarceration were offered. And I think we can benefit from private funding sources to support the work of agencies such as VERA and PPI, who we heard from in previous presentations, previous meetings. And I think we may be able to extract, kind of agree on a common core set of metrics and focus on those. And I completely understand the hesitancy to spend money to create new case management systems for 24 individual offices. And I think for most of the jurisdictions, that wouldn't be necessary. You know, the existence of standardized and publicly available data can increase the public's faith in the criminal justice system. Research shows that fairness and legitimacy of the criminal justice system promotes community cooperation, and those same criminal justice cooperations with those same criminal justice agencies, which ultimately can help to reduce crime and to make the state safer. So I hope that we can reach an agreement to work within these existing data structures to identify a practical way to come up with a common set of metrics throughout the state. So I'll end there and happy to take any questions.
Thank you very much, good doctor. Are there any questions for Dr. Soleil? If so, just put up your hand function and
I'll stop sharing my screen so we can see.
Awesome, thank you.
I do, from State's Attorney's Office in Baltimore City.
Yes, sir.
I'm putting out a hand function. There it is. So let me say, Dr. Sewell, incredible. I agree 100% with the last quarter part of your presentation and in having key data points and a list. I think if anything's going to get accomplished, you have to have an idea of what you want to collect, right? And number one, it looked like obviously you can pull it by jurisdiction. So already, just with the data that the Sentencing Commission holds, you can do this by jurisdiction. The other one is, are all the data, all the points that you're collecting in the form, are they reportable?
Yes.
Great, right? So if they're reportable by jurisdiction, then you mentioned portions, probably 10 to 12 things that were not currently being collected that
Right.
look like important data points that I think individuals be interested in. Would it be difficult to modify the form and then begin collecting those if the committee wanted that, or if that was a recommendation? Would it be hard for that to happen, seeing that it's already cross jurisdiction?
That's a fair question. I understand that point. Yeah, that's good. It would be difficult, and I'm not sure it would make sense because a lot of the information pertains to charges, right, that were dismissed or dropped, or and so the guidelines are calculated only on final convictions. So I think it could even be problematic to have, I wouldn't want a sentencing judge to also have, when he's considering someone, the guidelines for someone, to say like, oh, okay, well, he also had these 6 charges that were more serious charges that were reduced or dropped. So the guidelines wouldn't take those into consideration in calculating them. So I think I don't think it's the greatest fit to like try and pigeonhole them into the guidelines worksheet. And then the other portion of it is that the guidelines, again, are limited to just circuit, original sentencings in the circuit court.
Sure.
So it would miss a huge portion, as I showed in one of those graphs, of prosecution statewide.
Yeah,
Right.
I totally understand those restrictions, and I get that. It's more that if they're looking for something that's already broadcasted across all 24 jurisdictions, there's great data in there. There
is some great data in there, and the good news is that Sentencing Commission data is already publicly available. It's
right.
we have. Anyone can request it. It's available. We have all, we do multiple reports on it. We have a crimes of violence data dashboard. So there is a lot of information out there already. So that's the good news about that. But I don't think getting at a lot of the information that might be of particular interest to this task force.
Thank you.
We're
going to move the delegate Valentine, and then State's Attorney Gibson.
Thank you, Mr. Chair, and thank you, Mr. Soleil. I did have one question. I believe it was on your second slide. It was the 783,000 figure. Could you explain how you came to that number and what that number actually includes?
Yeah, so I used that to calculate. It was sorry, I'm trying to bring up my presentation, but it was the total number of criminal circuit court case filings, district court case filings, and motor vehicle filings in a particular fiscal year, which was fiscal year 2019. So there are case filings. So we extracted that from the court's data, statistical report that they do.
Now, would that include, say, non-serious traffic that would not be associated with the state's attorney's office?
Potentially, yes.
Okay. I just thought that number seemed kind of high, so that kind of explained.
Right.
Thank you.
Mr. Gibson.
Thank you. Just a point of clarification. So judges, when they render a sentence, when sentencings are done, they hear everything that they have available, everything that any party wants to raise. They can consider anything. So uncharged prior offenses in other jurisdictions, whether they're, whether they're an altar boy or a nun prior, all the information that one would want to present to give an accurate reflection of the defendant before the court is presented at sentencing to the judge. So that information it may not be part of the sentencing guidelines form, but it is before. I just want to make sure that was clear.
Gotcha.
Seeing no other questions, I did have one for you, and just for clarification of this commission and the general public, the information that's within the guideline sheets that you went through, that information is input by the courts and state's attorneys, or whom is it that? Okay.
Yeah, state's attorneys are doing, we call it initiating the guidelines worksheet. And like I think I said during the presentation, they do about 90%. The other 10% is when a PSI is ordered, parole and probation investigator is initiating the guidelines. But for the overwhelming majority, it's the prosecutors that are doing it. They initiate the guidelines, enter the overwhelmingly bulk of the information in there. And then after sentencing, the judge or the judge's staff is going in and entering, what was the sentence information. And then if there was a departure from the guidelines, providing, their reason for why there was a departure from the guidelines.
Got you. Thank you very much. And thank you for your presentation. Seeing that there are no additional questions, David, did you want to take over this portion?
You're doing such a great job, Senator.
All right. I'm sorry, Ms. Warnken.
Oh, thank you, Senator. Yeah, I just had a follow-up question as well, based on what you've presented and also Mr. Gibson's follow-up. I'm curious about opportunity for defense counsel and in particular public defenders to present additional information. And again, following up on your point, Mr. Gibson, about there's ample opportunity to present a lot of contextual information and background. And if you could clarify that, and it also has me thinking about kind of the end of our discussion at the last meeting on the lack of public defender representation in these dialogues.
Do you want me to clarify on that?
Either you or Mr. Soule, I would love just a little bit more illumination around that.
So when a defendant is
Dr. Soule, since it was your presentation, would you mind?
Oh, I was going to defer to Mr. Gibson.
Very
but
good.
Yeah,
Very good.
I got it. It's fine.
Very good.
I mean, I will say that the defense attorney, obviously, that the prosecutor prepares the worksheet. The defense attorney should absolutely go over the worksheet. They have access to mags. They have the ability to see the worksheet. They can challenge if, for example, let's say I don't think there was a weapon present in this crime. They can challenge that. They do that in open court. Their judges sometimes have to make clarifications in court. So with respect to calculating the guidelines, yes, they absolutely have the ability to have that input. It's just that the prosecutor is the one initiating it because they have the access to the criminal history information that's necessary to calculate the guidelines. I don't know if Rich had more to add.
Did you have anything you want to add?
Yeah, just that it is. There's not like state has the advantage situation. They're equal parties before the court. The defense counsel, Mr. Soule stated, has every right to articulate every fact, piece of information from the defendant's birth to the date they're in the court that would add light to the circumstances or would attempt to undermine the state's argument for whatever they're asking for. If they want to get a lighter touch or a lighter consequence from the judge, they can put any information before the court. The sentencing guideline forms are reviewed by defense counsel, and they could submit their own. And there are debates usually that happen before you get into the courtroom, if at all. Oftentimes there's an agreement. The documents, as I showed you in my presentation and Mr. Soule went over just now, are rather numerical in nature, and so there's usually not a whole lot of debate. The defendant either did or did not do X, and the facts of the crime are relevant or not, and you just fill out the form, and then you have a debate before the judge. But there's no disparity in the voice of the defense, whether it be public defender or otherwise, and the state as it relates to the sentencing. Each party is at an equal voice in rendering the facts and law before the judge.
That's really helpful. Thank you both. I mean, I would just add that part of my curiosity is around kind of from a practical perspective, what is the capacity of public defenders' offices to be able to engage in that?
Thank you. Mr. Smith.
Yeah, I just wanted to reiterate what Rich Gibson said. It's the same thing in Frederick County, Ms. Warnken. Oftentimes our guidelines are litigated. They're fairly objective data points that are put in there. Once in a while, there is some subjective data points, such as permanency of an injury that might get litigated or brought up. But for the most part, we don't argue over a whole lot. It's stuff that's pretty hard data. It's not a lot of soft data that goes into those guidelines. But I did want to reiterate what Mr. Gibson said, and that is that defense attorneys are always free to put in their own guidelines, and oftentimes they will dispute them because judges do want a sentence within the guidelines. So,
right,
Ms. Sahif.
Thanks, Senator. Sorry, just following up on Ms. Warnken's point. I'm assuming, Dr. Soule, that when a PSI is ordered, there's like a longer and more thorough social history of the person charged that's provided, and that only happens in 10% of cases. Is that right?
10% of guidelines eligible cases, but I would imagine that's it would be a much smaller portion of all criminal sentencings because the guidelines cases are the more serious criminal cases. So, yes, correct.
Thank you.
Wait, could you just repeat that stat exactly what that means one more time? Thank you.
Sure. 10% of guidelines eligible sentencings, right, which are as I kind of tried to explain, are the more serious criminal sentencings in the state. In the last fiscal year, that number used to be much closer to 20%, but it's dropped down substantially. The number of PSIs that have ordered has been reduced in recent years. So 10% of guidelines eligible sentencings, the judges are ordering a pre-sentence investigation. What I said was that it would be a much smaller percentage if you said what percentage of all criminal sentencings beyond the guidelines ones involve the PSI, because I think they're generally reserved for the much more serious cases.
Thank you.
Sure.
All right. We are going to move into our next presentation from the Administrative Office of Courts. Ms. Faulkner, the floor is yours.
Thank you very much, Senator. Good afternoon. I am Nancy Faulkner. I'm the Deputy State Court Administrator at the Administrative Office of the Courts. I'm accompanied today by Sarah Parks, a Manager for Business Analysis, Jamie Walter, the Director of Research and Analysis, and Kelly O'Connor, the Assistant State Court Administrator of Government Relations and Public Affairs. First, I want to thank you for the opportunity to present today on Maryland Electronic Courts, which is more commonly known as MDEC, and talk to you a little bit about what it is, its development, and some of the information that is within that system. MDEC is a judiciary-wide integrated court case management system, many years in the making. It's been about 10 years from the implementation, the first go live, which happened in Anne Arundel County, to the last one, which will be Baltimore City, which is slated for May of 2024. The process involves the conversion of multiple different court case management systems across 24 different jurisdictions into one centralized case management system. Prior to MDEC, there were many different court case management systems throughout the state. Certain circuit courts had their own individual case management systems that were different than what many other circuit courts were using. District court had 3 different systems, a criminal, civil, and traffic system, which themselves were typically different from all of the other trial courts, so all of the circuit courts. And there was a separate system for domestic violence. And you can see on your screen, there was a lot of different information that we were attempting to incorporate into a single system for the court to manage its cases. For example, 2 of the most recent courts to go live, which are 2 of our biggest courts in the state, Montgomery County and Prince George's County, had their own case management systems, which were completely different than anyone else was using in the state. Baltimore City, our last court to go live, our last jurisdiction to go live, the circuit court, and the district. The circuit court has 5 separate systems, and then we have the circuit court with it, the district court with its own individual systems as well that we're attempting to incorporate into one larger system. One important thing to keep in mind is that MDEC only incorporated court case management systems. So like the Sentencing Commission, and the information in MDEC does not have all of the information from prosecutor databases, such as discretionary prosecutorial information or any information that's not directly filed in the case. So the compilation of this information and this data is strictly from court case management systems. The process to integrate into a single case management system is pretty complex. As I had mentioned, it has taken about 10 years to roll it out, but there was many years of work that went into MDEC prior to our first go live. It involves a lot of changes in business processes, how information is collected and entered. And it can result in challenging is mapping converted data. So data that existed prior to MDEC that was converted into the system or put into the system, sometimes there can be challenges in mapping that data. So prior to joining the Administrative Office of the Courts, I was actually in court administration for 2 different courts as they went live on MDEC, Anne Arundel and Prince George's County. So I can attest to the tremendous amount of work and information that the staff at the courts and at the AOC get involved in to make this conversion happen. The ultimate goal for MDEC is for the Maryland courts to have a single case management system that allows the courts to effectively manage the flow of cases from filing to disposition. There are many benefits that are associated with this system. It allows filing of documents 24 hours a day. It allows the courts to have increased efficiency in many areas of case flow management. And what case flow management is, that's the life of a case from the time it's filed with the court until the disposition. So in a criminal case, that could be sentencing. In a family law case, that could be the order that awards custody. So it allows the court a lot of new efficiencies in managing its own cases. It helps the court generate court documents. It helps the court move case tasks along. So if an order needs to be signed by a judge, courts are no longer running around looking for a paper copy of an order. That's electronically in the system, and the court can move its own work within the system electronically. It also allows the court to monitor the activity of a case, such as alternative dispute resolution. So if a court case was ordered to go to alternative dispute resolution, the case manager or the clerk of the court can monitor that within the case. The main goal of MDEC was to integrate all of these case management systems so that the court could better manage its case flow. So it helps the courts process cases efficiently and as effectively as possible so that it can meet its mission. And I'm going to turn it over to Sarah Parks and Jamie Walter to talk a little more in detail about some of the different information that is in the system and how that flows. And then at the end, we welcome questions.
Thanks, Nancy. So we're going to talk a little bit about the flow of case information. In MDEC, the filer submits filings through what we call the File and Serve Filer tool. From there, the clerk must manually review those submissions and accept the filings through the File and Serve Review tool. Once the clerk has accepted those filings, they're sent to the case record in Odyssey, and then they become available in Case Search, Secure Case Search, the kiosk, and MDEC portal. Case Search and Secure Case Search only display case information, whereas the kiosk, which is available for the public in courthouses, and MDEC portal display both case information and documents are also viewable through those. So for the case information in MDEC, clerks must manually review all submissions, and they're also manually entering certain case information. But it is important to note that case information that is entered in MDEC is not all of it is publicly accessible. So good examples of that are sealed cases and expunged cases. The case information that is being entered into MDEC is based on information required for the courts to manage their cases and based on public safety reporting requirements. Now, I mentioned earlier that typically the flow of information starts with the filer e-filing submissions through File and Serve. There is an exception to that, and that is case initiation for criminal cases. So case initiation for criminal cases is manually entered by the clerks, and the exclusion to that is e-citations. So that means that at case initiation in criminal cases, the clerk is manually entering the data into MDEC, and the data is received from, it is contained in the charging documents. So that's where the clerk is getting that information. So the first thing that they start out with is manually entering the defendant demographics. So this is going to include the name, address, the SID number, if it's included on the charging document, sex, date of birth, race, and ethnicity, again, if it's included on the charging document. So we wanted to give you an example of what party information in MDEC looks like. Again, this is what the clerk is manually entering. They're getting this information from the charging documents. In addition to entering the defendant demographic information at case initiation, the clerks are also entering the offense and charge information. So this includes the CJIS code, statute reference, and offense date. And once this defendant has been sentenced, the clerk is also manually entering this information. Sentencing in MDEC is for the current case only, and it is manually entered once the disposition has been received and the sentence has been imposed. So the clerk is capturing and manually entering the disposition, any imposed sentence and time served, probation, if restitution has been ordered, any fines imposed, and if there was an alternative sentencing option such as drug court or home detention. And the alternative sentencing options are entered as docket entries in the case. So when we're looking at sentence information, the clerk is manually entering per charge the sentence. So they are including any time that has been imposed, and they can include credit for time served. Similarly, the clerk is going to manually enter any probation term and conditions as ordered. And then finally, if restitution or other costs are imposed, the clerk is manually entering this information as well. And so now I'm going to turn it over to Jamie Walter to talk a little bit more about the guidelines.
Thank you all. Previously, Dr. Soleil talked about the data that's available in the sentencing guidelines worksheet and did a nice walkthrough of that. I'm going to do a walkthrough of what the business process is for MAGs. And so, as Dr. Soleil mentioned earlier, the process starts with the state's attorney initiating the case in MAGs, although sometimes that can be initiated by parole and probation if there was a PSI ordered in the case. And then the next step for the courts then is that the judge's designee, which is typically a law clerk, will access it, in some locations will print the worksheet, although that really varies by location. There's some business process differences by court there. In some locations, the state's attorney's office will bring the worksheet to court. Then the judge sentences the defendant, and then the judge's designee will go back into MAGs and will complete the guidelines worksheet in MAGs, save it as a PDF, print it so that the judge can sign it. And at the same time, sort of parallel to that, then the judge's designee is going to submit the completed guidelines worksheet in MAGs. The printed signed version, the judge's designee will then scan that copy and have that signed copy uploaded into the case management system, into MDEC. That happens in all jurisdictions except, of course, Baltimore City, which is not, we don't have documents uploaded in Baltimore City Circuit Court yet. And then next slide. This is a view of how it looks in MDEC. So there's an events tab. And in that, the clerk will be able to then see this docket entry for the Maryland Sentencing Guidelines worksheet that it's been filed. And then to the right of that, you'll see this hourglass. And when we click on that, a box pops up. And then when the box pops up, it will show those two documents. The guidelines worksheet is the second one that's visible there, and there's a little PDF icon. When you click on that PDF icon, this is the next slide. This is what you would see. So you click on the worksheet, it opens up in a PDF viewer. So the vast majority of data from the worksheet is in PDF form. All of the detailed information that Dr. Soleil walked through is available in MAGs, but it's not something that the clerks are then re-entering into the case management system. And that's it. Questions?
Thank you very much. Do we have any questions from the commission? Yes, Ms. Saif.
Hi. Thank you. Could I ask what cases end up being filed? Like, is it only a case? Is it a case that is once it's charged, it's filed, or is it only the cases headed for sentencing or plea? Or
So all of the cases that would normally be filed with a court would get into the case to our case management system. So if they're getting charged and the case is getting prosecuted, it ends up in our case management system. If the prosecutor is exercising some discretion not to prosecute, we don't have that information. So the only information that ends up in the MDEC system are those cases that are actually prosecuted. And Jamie, I'll turn it over to you to talk a little bit about which ones show up in MAGs.
So the MAGs one would be only ones that are the guidelines eligible. So, remember that slide from Dr. Soule, we're kind of filtering our way through. There's the prosecutorial discretion to even bring the charges and a criminal indictment or information. And then from those, which ones have not are guidelines eligible, and then there's going to be a sentence imposed, then we'll have that sentencing worksheet completed.
got it. So thank you. So I know that Dr. Soule's system, I'm sorry to call it your system, but you know what I mean? Okay. System only captures cases that are at sentencing. So you actually capture all cases that are filed. So if someone wanted to count, for example, the number of cases dismissed, looks like those numbers could come from MDEC, right?
That's correct. We would have that in MDEC or in Baltimore City's case management system. But the piece that we would be missing is if there's prosecutorial discretion in bringing the charges to court at all.
Right. Also, would you be able to see like would you be able to, from your system, from MDEC, categorize, oh, these are the number of robberies that didn't make it, that were dismissed for some reason. This is the number of, DV assaults. This is the number of drug possession cases. Would you be able to segregate by that as well?
Well, the way you worded that question is a little complicated. So we do have the CJIS codes of for each charge. Domestic violence assault. So domestic violence assault is not a charge in Maryland, it's assault. And if there's a domestic relationship, that would be something that the state's attorney would have to note at disposition, and whether I don't have any sense of whether they're noting it at disposition or not. I don't have a sense of whether those numbers would be correct or not. They would have to indicate that it's domestically related.
But you could segregate by all the statutes of these are all the assaults that were dismissed, or these are all the robberies that were dismissed.
So we
because
do
you'd be able
have,
to see.
right. We do have the charge and the charge description, and then we have the disposition for cases that have been disposed.
Okay, so the disposition, and the reason for disposition is not included, right? But the disposition is included.
If you mean by reason, so we have disposition such as dismissed, for instance, or null pros, or guilty, not guilty.
We don't have data on what the reasoning behind that dismissal was.
Got it. Thank you so much.
That would be in the court record if you had, we wouldn't have that searchable.
If at all. It may not even be in the record at all.
Yeah.
All right. Were there any other questions? Okay. I know one of the slides had mentioned something about e-citations. Could you remind me, are they included or not included in the system? I forget from the slide.
So e-citations are included in the system. They're just not manually entered by the clerks.
Got you. So the information, is it automatically, our system's talking and it's automatically populated, or how does that work?
It does get integrated into the system automatically. The difference is that for traditional, I guess you could say, criminal court cases, the clerk is receiving the charging documents and manually entering those. Whereas with e-citations, there's more of an automation to it.
Great. Thank you very much. And seeing that there are no additional questions, I thank the administrative court for their time. We're going to move on to the case management systems portion of this. And Mr. Smith, if you wouldn't mind kicking us off.
I certainly will. Thank you, Mr. Sidnor. Thank you, Mr. Moon, for having me on. Unfortunately, I'm old enough to remember when case management systems comprised of manila folders, index cards, and Rolodexes. So we've come a long way from there, and in large part due to MDEC, quite frankly. MDEC really drove technology acquisition for all of the state's attorney's offices across the state. Fortunately, Frederick County was an office that adopted technology very early. We were paperless, as they called it. All the prosecutors going to court with laptops and tablets many years ago. And actually, Darren O'Brien, Darren, I see you're still on there. We were on a technology committee actually for MSAA. Boy, it's probably 10 years ago. So we definitely understand the importance of having a data points and data collection within our offices. Now, interestingly enough, early on, my main objective was really to build internal support. It was really internal transparency and internal equity, quite frankly, when it came to workflow, workload. We wanted this data, we wanted this analytic work, and being able to incorporate data into our regular staff meetings, into our communications. We wanted quantitative metrics for individual performance reviews, case assignment, et cetera, et cetera. So, because we thought that if we could improve our data collection, we could improve our product for the public, right? Public safety, criminal justice. We would be able to do things better, more fairly, and have just do our job well. So, we adopted a case management system that was the same as Baltimore City, and a couple of other jurisdictions had it as well. It was called Judicial Dialogue. But one thing we found in the technology committee when we brought all of the counties together in the city was that it was very fractured. Even though JD, as I'll call it, had maybe 5 jurisdictions, there were 5, 6, 10 other jurisdictions that had different products, and many had none at all. Quite frankly, they had to adopt something in order to comply with MDEC, or in order to get the information from MDEC. So the first thing I want to tell you is that it still is that way. I mean, we're not manila folders anymore, but we are all very different, and a lot of that was driven by a lack of funding. We actually had a proprietary one we built in-house. Montgomery County was similar to that years ago. But now we're all purchasing relatively canned products, I'll call it, in order to effectively prosecute our cases using case management system. But the big picture for both of you all is that the focus has always been on getting data. In other words, what can we get from MDEC in order to, automatically populate fields for our case management system, et cetera, et cetera. The focus has not really been on giving it. And so that's one thing that we found early on was a lot of what we were doing was collecting data out of MDEC, and it was a lot of narrative field type of stuff. And so when we collaborated with PPI, which is prosecution performance indicators, and I believe it was mentioned earlier who they are. It's a nonprofit. It's funded by Microsoft as well as other nonprofits. Is a collaborative effort by about 5 counties and Baltimore City in the state to basically get these performance indicators, because we now have focused on not just getting data, but now we want to give it. We want to be transparent. We want to have what they call data dashboards, which is just basically a website you can go to. And I believe Ryan's going to address theirs a little bit more in depth after I speak. We're one step behind them in terms of collecting data. But what we found was we just didn't really collect our internal data very well. I mean, we did, but it was all narrative fields. So this happened at trial. This is, what transpired in terms of the plea agreement or whatever. And the researchers, which are all part of like University of Maryland, Bowie, Florida International, who else is there? UMass Lowell, and one more, Loyola Chicago. These are all these data experts, which has been really great. They've come in and say, you guys, your data's a mess. We're like, wow, we thought we were doing it pretty good. We thought we were collecting it. We thought we were doing the right thing, trying to be transparent internally, knowing that someday we'll have to be transparent externally. But it was just a real mess. So they came in and they've just spent, boy, a lot of time just trying to clean up our data, much less like software acquisition or anything like that, but how we put all this in and what fields do we want to have internally in our case management system. So I think when somebody was speaking previously about MDEC, I thought that was a good analogy. I mean, how long did it take MDEC to roll out? How long did it take to kind of routinize all this data and make sure all the counties can kind of play in the sandbox? It took a long time. And unfortunately, my message to you today is that this too is going to take a long time and it's going to take money. But I could tell you Frederick County individually, I won't speak for other counties because I know Rich and I generally see eye to eye, but we have a little bit of differences in terms of how to push data out. It's going to take a long time, but we're committed to it. I do believe that the most important part of the case management system is to, and someone spoke before, I think David spoke before about getting a core set of stuff that you guys want from us, because we've seen some of these data points that are just, they're either impossible to collect, like neighborhood, not sure really what that means, or are they poor? I'm not sure what that means. And we don't have the authority to obviously fill that field. I can't ask you how much you make or whether, you're on government assistance of some sort. So my chief concern, and I'll let you go at this, is that, we want to limit the PPIs, the prosecution performance indicators, to a core set of metrics that are fair for us. And not to get into kind of touchy subjects, but I saw like somewhere else in a different system or a different legislative initiative where they wanted to collect the race of the prosecutor. And I thought, at first I'm like, well, I could see that as a metric. And then the more I got to think about it, I'm like, wow, that would be a horrible metric to collect. I mean, I wouldn't want someone looking at me as a white prosecutor or her as a black prosecutor and saying, we're going to judge you on the color of your skin based upon how you treat all of your cases and defendants. So I do think that there is, unfortunately, a real dangerous side to the giving data. But I do believe that if we collaborate, we can come to a core set of metrics that we all agree on.
Right. Let me ask you this, Mr. Smith, because I'm not aware of your time. Do you have to leave, or is it all right?
I don't. I'm good. Yeah, I'm good.
Very good. Then what we will do, we'll move on to Ms. Wexler.
Okay.
Hi. I actually also have a short PowerPoint that just kind of has a couple of things from our dashboard that I can put up. I think someone has to give me.
Yeah, Claire, would you mind giving Ms. Wexler the ability to share?
She has been designated as a co-host, so she should be able to share her screen.
All right, hold on. Sorry.
Great, thank you.
Oh, here we go. Share screen. Right. Is that working?
Looks good.
Okay, good. So this is kind of our home page for our dashboard, and on the top, that's the website that hopefully you can enter, and it should bring you directly to our dashboard. You can also, anyone can get to it if they go to the Montgomery County State's Attorney's website. There's a link that will take people to the dashboard. In terms of why we tried to create this dashboard and the history, I would say several years ago, the community was asking us a lot of questions, and we quite frankly didn't know what the answers were, because our case management system, and I think this has been spoken to before, was not set up to accurately and adequately give data out the way that people wanted to see it. And we started really looking at our case management system, and it was a mess. We couldn't rely on it really for much of anything. It was kind of where we stored discovery and we stored documents. But in terms of even kind of checking people's caseloads, it really wasn't valuable because it was a mess. So the timing actually worked out. We started talking to PPI about, what they could help us with and what we could do. And in the same period of time, our case management system, the contract kind of expired. So we had to find a new case management system anyway. And we had to really build it. Although, as Charlie said, it's a canned system. It's certainly one that you can have input into what pieces of it you want to take and leave behind as you're building the system with the people from PPK. I will say, I think it cost us like $1 million to put this system in, to buy the system, and will continue to cost money as we go forward with maintenance and with just the capacity to store all of the data that is in there. So it certainly wasn't cheap. It also was incredibly time consuming and difficult in terms of implementation and getting an office of almost 200 people to learn this new system, to try to buy into a different sort of data culture and try to start collecting information in a different way. So it's a work in progress. I'm just showing kind of snippets from what we have up there. And the first thing that I wanted to show was we have in there a diagram of kind of how cases move through the system in Maryland. And it's certainly, simplified, I will say. There's different things that could happen that are not on this chart. This is really just for basic understanding of what happens from when there's an alleged crime all the way to sentencing and kind of where things can branch off. Something that I don't know if it's been discussed or not in this forum, but Maryland is very different than the vast majority of other states because Maryland is a direct file jurisdiction. And so what that means is cases are charged by police or can be charged by individual citizens who go to the commissioner and allege a crime, and a commissioner can sign off on charges. In other offices, when cases come in from the police, other offices, including the district, have a unit, I think, that basically go through and make a decision. We're going to take this case, and this case we don't think has merit. And then the prosecutors make that initial determination of what moves forward. So when talking about, and I kind of will come back to this later about, these data systems helping with resource allocation and helping with kind of case management in terms of caseloads for prosecutors down the line, that doesn't apply in Maryland because that whole first step doesn't exist. We have to have our prosecutors going through all of our cases post-charge. So it's a different system, and it took us a long time, I think, to explain to PPI and to the researchers data points that they wanted to explore that don't exist in the state of Maryland. So I think that's kind of important to note. And then just going through different pages, and they don't look like this on the website, they're prettier, but I just kind of pulled out certain charts. We have certain things that we were able to look at, which is numbers of cases filed by offense type and year. And on the website, you'll see in this top corner, it says person and then parentheses non-murder. So that includes, cases like assaults or robberies, person-related offenses that don't include murder is basically what it is. And you can see the numbers throughout the years. And if you go to the dropdown, you can look at different categories of crimes and see that, those statistics. We were able to look at the numbers of cases by offense type and year. Again, in terms of drugs. So the first two next to each other are the same chart with different choices from the drop-down menu. And then on the bottom, it's kind of the similar information, but it's just shown differently. So you can see in 2022, there were filings of 656 person non-murder related crimes that were charged, and then drug cases 219. One of the important things to note also is all of this is circuit court information. We did not put in anything in terms of district court. And the reason for that is it was, I mean, I think someone talked about, I think Charlie talked about cleaning of data and how hard it was and how much time it took. It took 2 years for researchers to clean the circuit court data, which is the vast minority in terms of numbers of cases that we process. And it took them 2 years to get, you know, minimal to moderate information that was good out of it, because it was just when information comes in through the state feed from the AOC, it wasn't cleaned on the front end. So we had duplicate names. Let's say we had 30 John Smith that were the same John Smith, but sometimes it was written differently, or there was a typo, and sometimes the date of birth was one off, but it was the same case and it was the same person, but the system didn't know that. So it was really, really hard to kind of work with the junk that was in there. Hopefully that will be fixed in the new system as we go forward. But I will say part of the fix for that is we had to create a position for someone who literally goes through every single case as it comes into our office and checks to make sure that that isn't happening. And that is a huge issue with resources. You know, everyone has a ton of work to do, and that's a full-time position that we didn't even really anticipate we would need. So we also have information on victims. The important thing about this information is if you look at the bottom graph, this is from the information that we had collected in our system. I will say the majority of cases, we didn't have victim information entered because it doesn't come in most times in the automatic feed. It has to be entered by prosecutors. So I would say this would represent maybe a quarter of cases in circuit court where we did have victim information. But finding victim information is not easy. And it's also problematic in other ways that again, I can come back to. So this data, although we put it out there, I just want to point out that it's, you know, it's a very small subset. And then we have guilty pleas in terms of broken down by race. And then on the bottom two, it's differences by defendant, race, ethnicity for Black defendants. And then on the right, it's Hispanic defendants. What is important to note about this is for our study, ethnicity was nearly impossible to collect because years ago, and I want to say it's before my time, but it may not have been, but years ago, and I think this is statewide, there was a decision, it may not be statewide, to take ethnicity off of the statement of charges. And so police specifically don't record ethnicity because individuals were concerned about collateral consequences of collecting that data for defendants and for the safety and protection of defendants and the potential it would have for, you know, ICE consequences and things like that. So we literally, that's a blame for us on any of our cases. So what they did was they took, and I hope I don't get this wrong, but there's a list of the top 100 names, I think, associated with Hispanic individuals. And they literally, the researchers, that's how they identify in our system, the Hispanic population, which is certainly not perfect. It's, the best we could do, but I don't, going forward, I don't know necessarily how to fix that problem as we update the dashboard, because we don't have that information. There's good reason, I think, why the police don't collect that information. And, it kind of falls into the category of information we'd like to have, but how is it going to get there and who's going to collect it? So that was kind of all I had for the slideshow. And now I can talk about kind of the issues that I think we faced and continue to face. And the biggest one is funding. The dashboard, when we created it, was funded by grants through PPI, and they helped us put it together. And obviously the over 2 years of data cleaning and all of that work they supported. But going forward in this budget cycle, we are asking for a data analyst. I don't think it's physically possible to keep up this work and this dashboard without that position existing. The amount of time it takes to do this is, again, it's a full-time position, and it's a full-time position that, frankly, I'm not qualified to do, and I don't know that anyone in my office would be qualified to do, because these are statisticians, and I certainly am not. I think there's also an issue with additional staff in terms of trying to make sure that the data that is entered is accurate and that it is entered at all. Because a lot of what we want to look at is prosecutor decision points, and that's really important. However, it's also incredibly difficult to track, and it needs to be tracked kind of individually and by prosecutors, and it takes a lot of time and a lot of resources. And if we wanted to be able to really do it, I think it would take staff whose job it is to enter that data and make sure that it is accurate as a check. Because the worst case scenario is, we collect data and half of it's wrong and half of it's missing. And I think that's a real concern. When looking at kind of the sentencing guidelines and what is collected there and what's collected through the state system, the biggest problem we face is none of those systems interact in a way that is helpful for what this task force is looking at. So an example is in terms of data that's put in by AOC, we have information that comes in through the state from what they were saying before, from what the clerk enters in terms of defendant's name, history that they're getting from the statement of charges. Then on the back end, they also deal with case closures, but the language that's used and the way it's entered does not translate into our case management system. So what we were finding is what's coming in turns into junk data. There were things that came in, it would be guilty plea, but then there would be a whole section for other plea, and no one knew what that meant. And then there would be, kind of acronyms or ways to shorten things or information that was unrecognizable to our system and to the people that were trying to look at it. It doesn't translate, and it's a different system and it's kept for different reasons. So while all of this data exists, it doesn't exist in a way that makes data analysis possible to the way that we would want it to be. We enter guidelines, but we don't enter guidelines information into our data management system. And so we enter it, and then there's a PDF version of it, but that doesn't help statisticians look at guidelines information. So it's just the problem that we're kind of coming into really is that there's all these systems that are different and don't talk to each other. And to fix that problem, I wouldn't even know how to begin to fix the problem if it's possible. And also the time and the resources to do so would be, I think, kind of a Herculean effort. So we're, committed to doing this, and we're committed to trying to keep our dashboard up to date. Hopefully we will get that position, which will allow us to do that. And, we'll do the best we can going forward. But I certainly would say on a statewide level, there's a lot that would need to be overcome to make it all possible. Thank you.
All right. Thank you, Ms. Wexler. Yes, Mr. Smith.
Yeah, I just wanted to reiterate what Ryan said and tell you that once PPI leaves Frederick County, that'll all stop. There's no way we have sufficient funding to continue what they've done. Ryan, I don't know about you. I can't imagine the hundreds, if not thousands of hours that they've put in to just trying to mine our data and get us up to speed at just collecting usable data for a base set of metrics, performance metrics, or transparency metrics. And I think whatever they give us, and whenever they're done and whenever their Microsoft grant runs out, that's what our data dashboard is going to look like. We're just going to have to walk away from it and continue to just kind of prosecute and push out whatever it is that they've enabled us to push out. But because we don't have, God bless you for trying to get a data analyst. We certainly don't have that, and we certainly don't have the software programming money. Not only do they give us recommendations, which would be extremely costly once to get an outside agency to do that, but then you have to implement those recommendations. You have to do what they tell you need to be done. They're just telling us what they think needs to be done. They're not doing any programming at all. Zero. They're not going into our case management system and telling us how to collect it. They're just telling us what to collect and what our system fails at doing. And then we have to go back to our vendor and say, hey, can you do this field? Can you do that field? And they're like, well, it's going to cost a lot of money. So, not to kind of beat that funding drum, but I think we're done once they leave.
And I would say also, in terms of, again, I totally agree. It's not only they're saying, this would be helpful to know. I think we all agree that we would love to have a lot of information, but, in terms of victim information, for example, trying to put that in, first of all, you're asking individuals, either prosecutors or victim witness coordinators, to just kind of eyeball someone and make their best guess as to someone's race or ethnicity. Because the other alternative is asking victims a lot of questions that I certainly don't think are appropriate for prosecutors to ask and collect. And I think it would have an incredible chilling effect on victims who would be willing to be engaged in the criminal justice system, which they're concerned about anyway. So while I appreciate the desire to have that information, the same thing with, defendants, and income or, neighborhood, things like that. I certainly appreciate the desire to know that information, but I think it's inappropriate for prosecutors to gather that information or to ask those questions. I think that's incredibly invasive to someone. And honestly, as a defendant, if someone's trying from the prosecutor's office to find out what my income is, that would be really concerning to me. And I would have a lot of concerns about whether I was receiving justice in that jurisdiction. I just don't think it's an appropriate or fair question for us to ask and information for us to collect, as much as we may want to know the answer.
Thank you very much. And we're going to go on to Mr. O'Brien, and then we'll open it up for questions.
Well, good afternoon, everyone. I'm going to share my screen. I think you should see it. Let's see.
You see it?
So I'm just going to start very quickly look. A good student does their homework. So I did some homework, and that was I listened to the 2 prior meetings. And I'm so glad I did. So Darren O'Brien, Baltimore City State's Attorney's Office, 20+ years, prosecutor, Director of Information Technology, helped develop case management, one of the case management systems that's being used in the state now. But what I want to start with is, after doing that homework and listening to Mr. Charlie Smith and the Deputy State's Attorney, and having heard Rich Gibson's presentation, there's a lot going on, and I am incredibly happy that everyone is just on point with this. It cannot be an unfunded mandated request. It can't. The amount of expense and time that it takes to develop these systems to the point where you would like this information is incredibly costly. And that's where I'll go into why Baltimore City is so different. The Baltimore City State's Attorney's Office is the one and only jurisdiction that has an internal IT department. So I'm the Information Technology Director. I have a certified database administrator. I have an applications developer. I have 2 network engineers and 2 help desk individuals. And we maintain an entire WAN and LAN network, 7 buildings, fiber, switches. The amount of knowledge and technical skills that we have are just unfair. So our system, as University of Maryland has said, we have some of the best data. We have great data, but that's come at the cost of having staff in-house that are dedicated to making sure that the infrastructure, the database are in place. We have an internal individual DBA who helps fix the back end, who helps pull the data, who actually acts as a data analyst. So when you talk about staffing and everyone, the key term now is analyst. An analyst is going to be anywhere between $40,000 and $80,000. A database administrator is going to be about the same class category, and that individual can do 6 times more what an analyst will be able to do for you. Not only can they help manage the back end of your database or your structure, whether it's Oracle, SQL, any of that technical information, you're going to get more money. So if anyone's looking for money and the state wants to fund a position for the state's attorney's offices, they would get a DBA for them immediately. And that would help them cultivate the data and the data points, the collection of, and the dissemination and reporting. So that's just a critical thing to know. So number one, we have the right staff. We manage the case management system. We're trying to change the culture. This is a big cultural change. As Mr. Smith was saying, years ago, it was paper files, and we've moved to electronic case management systems. That's not generally the job of a prosecutor or even the support staff to be entering those data points. But that's a big cultural change, and it is funding required. It's not going to happen with current staff. So our database, we use something called Judicial Dialogue. We integrate data. There were 11 questions that were asked to be discussed. So we collect data, and this, again, we're very different because we have an internal IT department. So we're pulling data from DPSCS, the Baltimore City Police Department, MDEC, Axon. If there's an agency outside of our agency that's willing to provide data to us, clean data, we're going to develop an API and we're going to pull it in. But again, I don't think any other jurisdiction in the state of Maryland has the funding. So you have to understand that Mr. Smith and Rich Gibson are reliant on their local jurisdiction's IT department. And I guarantee you the state's attorney's office in that jurisdiction is not a priority. It's going to be the executive, or it's going to be the mayor. It's not going to be the state's attorney's office. They don't have someone they can call and say, hey, we want to collect another data point, or we want to create another form to collect this information. That's not happening. They don't have the staffing to do that. So consider that in the development of what you're attempting to achieve. Local jurisdictions, this is key. Mr. Gibson mentioned this. So each election, look, we're fortunate. We are absolutely fortunate. 4 or 5 administrations, and we finally have a state's attorney, Mr. Ivan Bates, who is absolutely one of the best, because within 30 days of him coming into this office, I was scheduled to attend a data transparency meeting for the state's attorney's offices. So, and why I bring that up is every time another state's attorney is elected, the goals change, the data points change, the database itself and the information that can be collected can change. We've gone from sort of a non-transparent administration to now a fully transparent administration. And we're in the midst of building, in the middle of building forms so that we can collect that information. You know, the citation docket, that was, you know, one of the first things. He made a promise. We fulfilled that promise, but he had to collect that data. That, I'm not so sure any other jurisdiction would be able to do that. And the reason I'm driving that home is it can't be an unfunded mandate. You have to have people. You have to have the ability and the cash and funding to change that database, to manipulate that database, in order to collect that data and the data points you want to report accurately, right? So our case management system, another thing that you need to understand is that in 24 jurisdictions, whether they have a case management system or not, they are all very different. And each of them, you will see there, I think there are 6 jurisdictions that use the current case management system, Judicial Dialogue. And there are 3 key case management systems in the US. It's Matrix. In order, it would be Matrix, Judicial Dialogue, and then KPL, or Carpel, right? And there's reasons for that. Every 3 to 4 years, my fiscal responsibility is to review case management systems. And if we have the funding, I would change it. If we don't have the funding, I'm not going to change it. I'm going to continue development internally. Again, something that other jurisdictions just can't do, because I have the staff to do it and the knowledge to be able to do it. But for example, Carpel was going to cost us approximately $1.6 million. Matrix was going to, $1.4 million for Matrix. And that does not include the annual licensing and maintenance fees, which range in an agency our size between $300,000 and $400,000 a year. So if you provide the right staffing inside of a case, inside of a state's attorney's office, DBA, some analyst, maybe application development, then you can end up with a case management system like we have. And that's because we have the internal ability to make those changes in modified code. Another consideration in picking a case management system is the ability to manipulate the source. So meaning, is it open source data where I can change it? Do I have access to it to create a new screen, to create new reports, to do any of those things, new forms? That's key. Only 2 case management systems, unnamed until someone wants to ask the question, have that full capability. And that is that's something that if you're going out to purchase a case management system, you need to take that in consideration. And that's probably 25% of your decision should be based on what the capabilities are to manipulate that case management system's GUI, right? Very important. Most case management systems should be able to create, and again, this is because we really drove, and you can see this in the current state's attorney's goals, is driving data internally in order to manage and facilitate efficiency. So I'm just going to click through a bunch of reports that should just be standard throughout the state. Again, probably not, because there's not funding in those other jurisdictions. But this is a closed case form. This is directly related to all ASAs per unit. Daily closed cases and active cases. So we can run a report today and tell you non-statically every district court case and circuit court case that's closed, its sentence, why it was steaded or Nalprost. This is overall benchmarking. So this, what we do is we create statistics on the year prior and current year throughout.
So Brian, is your PowerPoint moving forward?
Yes. Are you seeing?
We see the same screen. At least I am. I don't know if anybody else is, but it's the same landed the screen with the blue field and that you first started off with. There you go. Okay. Thank you.
I apologize. So let me go back here. So are you seeing closed cases?
Yes, sir.
All right. So the real quickly, just reports that should be available. An example of how data can be collected, the case management system, how you're using a case management system. You can buy any one of the 3 case management systems I've mentioned, and there are probably others that other individuals feel are just as robust. But if you have the internal staff, this data points can be collected and reported, because most of the data that we're pulling is data that's been collected by MDEC. We're just using it to display internally and create internal metrics so that we can drive change inside the agency. This is an overall date range. You can run any date range and it'll show you exactly what the reason for any stet Nalprost was, and throughout all of our cases, circuit court, district court. We have it benchmarked into about 32 different reasons: legal reasons, victim witness reasons, summaries, and then by unit. Just going to go through them quickly. Active caseloads. Well, no, this one's mandatory minimum. So you can do very specific things based on CJIS codes. You heard the representative from the AOC talk about the reports. There's a mountain of reports available in MDEC with that data. And you can get very specific, from CJIS code to age of defendant. There's a lot of data, and I'm going to close up my presentation with why MDEC is a good resource and why MAGS is a good resource. And they're already across jurisdictions. We're understanding that we all want that soft data, those narrative points. But let's go to another report. Active caseloads. This is critical, right? So state's attorney, we need to know what's going on. We need to load balance. This is all available. And it's all available because we're changing the culture inside. The deputy state's attorney that presented before me, Ryan, good point. It's the individuals inside the agency across all 24 jurisdictions. You need to change the data culture first. Everyone has to start to understand how important this is, remembering, as Mr. Smith said, the state's attorney's offices were never planning on sharing this information. This was internal. They built this to sort of try and keep track of what they were doing, not on their sentencing decisions or recording parole and probation recommendations. That was not the point. So the concept of unifying the state's attorney's office in 24 jurisdictions with one case management system is a great concept, but the cost is going to be, I don't think it's worth the result, right? So those are examples of reports that can be run. Again, ASAs, they can pull their caseloads instantly, one search. They can find all those things. Dashboards and PPI. So the main point with showing you that is that just about every case management system with proper funding inside, individuals, positions, DBAs, data entry people even. If you want that data to be rich, you have to supply that, and it cannot be an unfunded mandate. So PPI. So think about it this way. A decent solution to this, there is a fix, right? Where it seems like a monstrous task, but there is a fix, right? there's a way to do this. APIs, application program interfaces, can be used to pull from all 24 jurisdictions, right? There's going to be cost, but there is a way to do it. It's pulling data now, and mining data is very simple. It's whether the data is accurate. So each state's attorney's office is going to have to dedicate some time to changing the data culture. And then after that happens in a year to 2 years, then you can say, we need these reportable data points, right? All the things that everyone's been talking about from state's attorney's offices. Look, we have good, hard, concrete sentencing information, charging information, by CJIS code, defendants' names, defendants' dates. I think victim witness information is going to become a lot richer and a lot cleaner because of the way MDEC has developed the system. So in a year or two, say from 2022 to 2023, you'll be able to start pulling that victim witness information. But I agree with Ms. Ryan that some of those questions just are inappropriate, right? They don't, we're not there to ask those questions, not even our coordinators. Our coordinators are there to help them through most likely a very difficult situation, not gather background information for some data point that someone is trying to hunt down. I just don't think that's a very serious consideration. I think a lot of ASAs, I would not be comfortable asking those questions. I just wouldn't. It would never even cross my mind in a case I just handled. I wouldn't think about that. And PPI. So if you take MDEC, MAGS, and PPI, if we all could agree somehow that prosecutor performance indicators, and we could come up with the 10 collectible data points that this body felt was necessary, then I think you're on to potentially a plan. Because you can do general matrix and general performance, not the greatest performance measures, stats and null process, unless you have all the reasons for the stats or null process. And again, we have 34 or more. And that gives you an idea of why something was stated or null processed. So if we've seen in election cycles, a null process, cases are null processed because the feds are taking that case. That's not bad on our agency. It's not bad at all. They're null processed because restitution was made. That was probably a much better thing to have happen than a guilty. So a lot of good is happening, but you have to find collectible data points. I mean, I have learned that over a course of decades that the data points need to be meaningful and they need to be collectible. And we all know what that means. So if a potential way to resolve this is looking at the MDEC data and the data points that are there. I'm sure they can provide you with a table and a dictionary, and so can MAGS. And then this committee can look at those and then come up with some PPI indicators, which are the softer prosecutorial discretion points, and then come up with a clever way of developing those into a checkbox, a radio button, something that can be collected in a form. And that's why I asked the MAGS gentleman, thank you, sir, that was an excellent presentation, that those forms that already exist and they're across jurisdictions, if those forms, seeing they're in place, I understand that it's only in the felonies and those that fit the sentencing, but simple forms like that can go a long way if it's meaningful. If you really need to collect this data, that's a simple solution.
Thank you very much, Mr. O'Brien. So, do we have any questions for our presenters? Mr. Moon.
Thank you, Senator. Friends, I've been learning a lot over the course of these just a couple meetings that we've had, and I can't speak for the senator, but I think my head is probably swimming in the direction that you all would like, which is towards not coming up with a one-size-fits-all, trying to do something that's workable, that we can get buy-in with, and that frankly is able to be implemented. I'm a little hung up on a few points, though. One is the PPI cliff, as I'm calling it, that Frederick mentioned, where this outside resources and expertise goes away, and suddenly, poof, there goes accessibility. And so I want to at least split this conversation in two parts. One is the data gathering, And the second is the publication. And, you know, it seems to me we have to do this in stages and at least talk about this data gathering point first before we can swim up to statewide standards on publication in a meaningful way and make sure we've got this right. So I think it seems to me like we are talking about wanting everyone on a case management system and getting the data collection straightened out. But on this issue about outside expertise, resources, and personnel, I have to ask, because I've seen this question of resources come into play with police body cams, with MDEC and other places, and pretrial services. Some of this is where modern law enforcement is going, and we're heading towards an expectation that we're in the digital world, the data world, and not the paper world, and that the SA offices, state's attorney's offices, ought to get here one way or another, just like has been the case with body cams. And there's been a big debate about whether, you know, the state needs to fund this mandate. And on the other hand, people say, well, that's where the world is moving. Body cams are just a normal police tool now. Like what police department wants to operate without that tool? And so again, I know we started this whole conversation on a bit of an adversarial context, but just putting the publication aside, seems to me we want everyone on a case management system, a modern case management system, and then much of what we're talking about is just technology, modernization, customer service oriented improvements to the process. And so for those jurisdictions that already are using a CMS, don't you already have to have a database manager in place? Someone on, no, okay, I see the heads shaking already. I guess I'm really just curious to shake out what this personnel issue is. And again, you know, I'm not thinking about the Rolls-Royce treatment here, you know, like lowest common denominator. How do we move this thing forward in a way that encourages voluntary compliance? I have no idea if funds are available, but, you know, getting the small and big counties in line with some real basic stuff here. I mean, talk to me, you know, like why can't we set this ship forward with a real basic framework of data points and collection that are already available, recommend a case management system of some type, and then where we're at is, you know, this resource question, where that comes into play. I'm really curious. Are all of you in the place where a PPI disappears and that's it, no data dashboard? Some of the vendors were suggesting they have some fairly crude dashboards that they can make available without much cost to the jurisdiction. So I don't want to foreclose that we at least start somewhere like that. But I am very curious to hear more about this data management and personnel issue.
And who did you want to direct that question to?
Any of the current offices that are using case management systems already, how are they servicing the underlying database? I mean, it seems to me someone's doing something to get data in and to have some basic presentation coming out from some of the vendors' ends. There's got to be something already going on. Like, it can't be the case that if PPI goes, Frederick's got nothing working underneath its case management system. That doesn't make sense to me.
So I think we have Mr. Gibson willing to respond and Mr. O'Brien and I think Ms. Wexler.
Chair Sidnor, they're about to cut the cake. So
Did you want to hear from Mr. Smith then first? If you have a response.
I apologize. I do have to go, but Mr. Moon, thank you so much for your time. We have a part-time position that does very menial. They basically serve as a liaison to judicial dialogue people, and then we relate our concerns to our county IIT department, but we do not have a database manager. So truly, in terms of a forward-facing product, again, there is the cliff, and we would certainly, and once they're gone, we're done with any forward-facing type of medium to give the public these transparency metrics, unfortunately. So, but thank you all. I'm going to
thank you so much. We appreciate it. Thank you.
Yes, sir.
All right, Mr. Gibson, Mr. O'Brien, and Ms. Wexler.
Thank you, Senator Sidnor. So a big part of it has to do with purpose. So our data management systems, our case management systems are designed to allow, as I said in my presentation a couple weeks back, designed to allow prosecutors to have the ability to relate to our constituents who call in and to manage our own staff. It's not designed around an outward push of information. It's more designed around giving us the tools to interact with people when they have concerns in our community, to track the progress of cases with our prosecutors, and to interact with our prosecutors within the office or the office of management. In Howard County, we have our IT department is primarily focused on connecting us to our systems, and allowing the prosecutors to put on presentations in court, graphic design, things of that nature, put on presentations that are effective for our juries. There is, as Charlie mentioned, as Attorney Smith mentioned, we have a person who is a liaison to, we use JD as well, so same as Mr. O'Brien and Ivan Bates in the city. There's a liaison to JD, which carries our concerns to them. And then they in turn kind of hash through things, but JD does a lot of that external work. What we're talking about with PPI or Vera, or just pushing information out, would require someone in staff to kind of manage and mold that information, statisticians to track that information, and then people to do data entry in the way in which would be consistent with putting the information out. Again, we use narrative. It's a narrative form that we primarily use versus radial boxes or binary codes for I guess statistical scholarly purposes.
Mr. O'Brien?
Certainly, I have a great example for this. When you asked about funding and the right people, and why there's a cliff. So the reason you have someone in-house, right? A vendor typically, take any of the three that I mentioned, they come in, they sell you the product, they build the intake, the data coming into your system, into fields. They can, if you're hiring them, they can set up ways to push that data back out. But when they leave, they're gone. You can call them for help when things break, or you can have someone on staff that can do things like the following, right? So on every day to Baltimore City, 30,000 district court cases, 3,000 plus indictments in 2023. If an individual enters the data the wrong way, you need to catch that up front. You need to catch it up early. If the stet nalpros form isn't completed, and therefore you don't have the reason for the stet nalpros, or a closed case form isn't completed, and you don't have what the offer was, what the judge recommended, and what the actual sentence is. We have some internally because we now have notifications that go out to those ASAs when those documents aren't completed to get them completed. So there's a reason and a logic to have some, if you want good data and you want it reportable and you want it to be meaningful, there's someone cultivating that and managing it. And without that, the jurisdictions are they're great for 6 months. And then there's a clerk in one of the felony units or one at the district court who's entering the data the wrong way. Someone finds out, and guess what? In 300 cases, they entered the wrong data point. That jurisdiction that doesn't have someone is going to have to call judicial dialogue or call Carpel and ask, hey, we think the data is wrong. There's going to be an SOW completed. The state's attorney's office is going to have to find the funding to have that SOW completed to correct that data. So it's this collecting data costs money. Reporting data costs money. Have you ever used Power BI in a dashboard? I have personally hands-on built 3 dashboards, one for the city with Muncie and 2 for our agency. We have an internal and an external, and that's used by use of Power BI. It's one of the most popular Microsoft. It's the easiest one too. I'm no genius, but it takes someone to know the data, to place the data, to refresh the data, and to populate the data. It's not just, hey, everybody, you're going to do it. It does not happen that way. We'll entertain any conversation with anyone you can bring on board, technical, non-technical, and we can really talk about the actual costs and the time that it takes to do this per state's attorney's office. You really need to be looking at global, MDEC, MAGs, and then a company like PPI, and figuring out what those metrics are that you want each state's attorney's office to try and collect.
Will the State's Attorneys Association, have you guys have an inventory of which counties are using which vendor,
Yes.
or who doesn't have a system that we could take a look at? It would actually be interesting to know what exactly we're dealing with on a county by county basis here, cost-wise.
Mr. Gibson.
I raised it at the last, we just had a meeting and we're gonna collect that data and I should want to share with you. Generally, as was presented before, it's PBK, prosecuted by Propel, JD, and I forget the other third one, but there's three that are primary. Some places have none. I told you before, Talbot does not have one, but they're trying to acquire one. But I'll get you that information.
But just like off roughly, like are the ones without one of the big three vendors? I mean, how many are we talking? Like 2, 10?
Yeah. There are 24 jurisdictions. The overwhelming majority have something. Most have the big three that I mentioned in my presentation. I can't remember the third one. But JD and PBK are the lion's share, and there's the other one that has some smaller subset, and then it's probably 2, I want to say, that don't have, or 3 that don't have a case management system. But even within those different case management systems, there are different levels of options that each jurisdiction has. So, for instance, I have JD in Howard County, and Ivan has JD in Baltimore City, but the JD that Ivan has in Baltimore City is different than the JD that I have in Howard County as far as the panoply of options. It's like buying a car. You can get it fully loaded or you can get it, with different packages. And so that's the closest analogy I can get to that I think everyone understands. It's not like one standard thing. So having JD doesn't mean we all have the same JD, just that we're using that same system. Kind of like we're all driving a Toyota, but it's, there's a Highlander, there's a Camry, there's a Yaris, etc.
Delegate Moon, are you finished?
Yeah, thank you. Thank you, everybody.
All right. Were there any other questions for this panel? I had a question. I'm curious, and this is for Ms. Wexler, and actually, Mr. O'Brien, you can chime in if you want as well. With regards to the data points that you all chose, I think PPI had a list of 50 plus. I think I know 10 were mentioned during the course of here, but can you tell me how many of those data points you all kind of try to collect or do collect, and how the decision-making process about those particular points?
Sure. I mean, I think when we started, we were trying to be optimistic, and they recommended looking at picking, I think, maybe 20 or something to that effect that we were interested in. And we did that. But the reality was, when they started going through the data that we had, and I think Charlie Smith said this before, we were told that we had terrible data and that Maryland in general was unimpressive in terms of what data we had and how messy it was. So we wanted to look for a lot of things that, quite frankly, we didn't end up being able to kind of to end up looking at. What we tried to do as we built the new dashboard was start to give us the ability to collect some data. One example is, in our old system, when charges come in, once a case was indicted, let's say you have a robbery case, so it comes in district court on the statement of charges. And then if we indict the case, the prosecutor decides what charges to indict. With our old case management system, that information overwrote the previous information. So we had to merge these cases together, and we lost those initial charges that were brought by the police. So we couldn't go back and look at the difference between what was charged by the police and what counts were indicted. And that's obviously a huge missing piece of information. With our new system, we are able to now track that. So going forward, we'll be able to kind of capture information that we weren't able to do before. You know, another of the big ones.
And just out of curiosity, that particular data point in which you were just talking about, you could probably then use that if you're seeing a discrepancy, to then go back and retrain law enforcement officers about charging and the like.
Right. I mean, I think that the other important piece that, just to add to kind of and jump on the last question in terms of kind of keeping these dashboards going after PPI pulls out, is one of the things that PPI talked about, and I don't know if they talked to you guys about this, but was kind of data stories, and not just the importance of the raw data, but kind of the context. So I think it's really important to not just look at like the question that you asked, right? If there is a difference, where are we seeing the differences and what does it mean? And sometimes there are, you know, really reasonable explanations, and sometimes you need to dig deeper. I think in terms of resources and personnel, there needs to be someone who can look at the data, look at the context, and really analyze why we could be seeing what we're seeing. Because otherwise it's really just, it's not terribly useful unless you explain possibilities of you know, what's kind of making those things happen.
Thank you. Mr. Gibson, and then Ms. Warnken.
Yeah, thank you, Senator Sidnor. I just wanted to kind of like piggyback up for what Ryan was describing, because I think it's really important in terms of the meaning of the data is what's important. You can look at a fact piece, but not have any context for it. And the explanation is sometimes just lost, but it's really critical. The analogy was used in the first session we had relating to comparing criminal justice arena and prosecutors to the education system or the medical system, right? What the distinction is that the end product is different. In a school setting, a good student looks a certain way. A good product in a medical setting, same thing. A good end product is a certain way. In a school setting, a good student can take in information, can think critically about the information, and can use it and share that information they've taken in as they processed it. Right. In a medical situation, a good outcome is a healthy patient who has full functionality, or as full functionality as possibly be given based upon the situation. Right. In criminal justice, a good outcome is unique to the facts and the law and the situation. So in one instance, a good outcome might be to null process the case. The right thing to do might be to dismiss that case. That's what justice requires. In another outcome, it might be seeking every possible second of time that the state can impose upon an individual based upon their conduct. And so a good outcome doesn't have a common parent, unlike the school setting or the healthcare setting. And so in terms of how it all relates to where we are now, as Ryan just said, it's the context. Why the null process was done. Why count 3 versus count 1. Why pursue the maximum sentence. And that why is very hard to quantify in like a 1 second data point, which is why, again, we usually use narrative form as prosecutors, because we're in a world of stories where you need context, you need information to really fully understand whether the choice to pursue count 3 or count 1 or to null process the case was the right thing to do under the circumstances.
Thank you. Ms. Warnken?
Yeah, so I do have a quick question, but just a quick, response to that. I mean, I think there's also an argument to be made that context and stories are equally important in the education and medical field and in some other ways, and that good outcomes are also not so formulaic. So I know we're getting short on time and don't really have time to kind of unpack that comparison, but just wanted to respond there. But the question I had was actually for you, Ms. Wexler. I was curious about with the presentation of the information in the data dashboards, like, for example, the victim information, where for a lot of good and understandable reasons, it's such a small percentage. I think you mentioned maybe a quarter of the cases that information is available. Does the dashboard indicate missingness, or does the dashboard indicate sort of the denominator of how much of the victim information you're showing compared to the whole for people that are trying to consume that information?
So we had initially in that graphic, I think, the missing information piece, but I think what we decided to do was we explain this is for the data that we have. And again, I just kind of cut and pasted the graphs, but under all of the graphs are kind of what, like a little blurb about what you're looking at and how it's defined. And if I remember correctly, there's something under that that says this is for cases where the victim information was entered. It does not account for, or something to that effect. I think that's how we tried to handle that.
Thank you.
All right. Do we have any other questions for our panelists? If not, I would like to thank you all for again giving us insight into what's happening in Montgomery as well as Baltimore City. Thank you very much, as well as Frederick. So moving on, I believe we have heard from as many panelists as I think this committee likely would need to hear from. So I think our next meeting, we were looking to have it again in about 2 weeks on, I believe it's the 28th. If you all wouldn't mind checking your calendars, if we want to try to get back to our 10 o'clock hour, if that's good, that we can pencil you all in for that. What we will be doing at the next meeting is hearing from you all and having some discussions about what we've heard. I believe we've heard some good suggestions about how to move forward. Some that was presented today by Dr. Soule, in fact. So look to set aside a couple hours. I think we're on track. Again, receiving some really good information through the course of our meetings, and looked at as my chair, my co-chair mentioned, please come with your ideas. I believe we'll have a set of some recommendations as well, and I'll try to wrap some of this stuff up. Delegate Moon, did you have anything that you wanted to close us out with?
No, that's it. Other than we do need to try and start swimming in the direction of consensus recommendations, hopefully stuff that's implementable. Like the senator said, if we can start forming concrete conclusions, preferably in written form, I think that's the stage of game we are headed towards.
All right. On that note, we thank you for your time today and look forward to seeing you in 2 weeks. I believe we'll try to schedule this for 10 a.m. on the 28th. All right. All right, everyone. You have a great day, and see you then.